Welcome to video presentation 1 for criminal law. This is Professor Jack Guttenberg, and today we are going to discuss two different topics. The first topic to discuss will be the basis for criminal laws. The second topic will be the elemental approach to criminal law. Let's begin with the basis for criminal laws. There are two bases for our criminal laws. One of them is known as the common law. This is judge-made law. The other is the model penal code, which is statutory law. We will discuss each of these during this presentation. The first one is common law, which is judge-made law. This was created over the centuries in England by judges who sat in various courts at various times. They had to make the laws themselves because Parliament did not pass criminal laws for a great deal of the time. Many laws that are in existence today derive from the common law. Some of these are murder, rape, and larceny. We will discuss these over the course of this semester. Today, all criminal laws are statutory. That is, they are passed by state legislatures and the federal Congress. However, many of the state criminal laws today are derived from the common law. One example that you will see when we discuss murder later on is the Michigan murder statute. This statute starts, "A person who commits any of the following is guilty of murder and shall be punishable by imprisonment for life. Murder perpetrated by means of poison, lying in wait, or any other willful, deliberate, and premeditated killing." You will notice here that in this statute, the offense of murder is never defined. That is because the state of Michigan is relying on the common law definition for murder that had been derived over the centuries by the courts in England. Another example of statutory common law is the California murder statute. In this example, murder is defined as murder is the unlawful killing of a human being with malice aforethought. In this statute, you will see that murder is defined, and this definition is exactly the same as the common law definition for murder derived by the courts in England and used in the state of Michigan. The next basis for our laws is the model penal code. The model penal code was created in the 1950s and early 60s and was completed in 1962 by the American Law Institute. This is not the law anywhere. It is just a model, as you can see here represented by this model airplane. This airplane will not fly, will not carry passengers, does not carry fuel. It is not a real airplane. It is a model, just like the model penal code is not the law anywhere. But states have derived their laws from the model penal code. Now you may ask, why was the model penal code created? Well, over time, many of the definitions that were used at common law have obtained very different interpretations by different courts. Some of them at times are even contradictory. So it was decided by the American Law Institute, which is created and supported by lawyers, judges, and legal academics, that the time had come to try and rewrite some of these laws with new language that would have definite definitions and that could be universally applied. As a result, we have the model penal code. You will find the model penal code in your Dressler book at pages 937 through 1004. This will be referred to in the syllabus. You need to pay close attention when we are studying the model penal code because it is used as the basis for many state laws. It will be on your final exam and it will be tested on the bar exam. So you will need to pay attention to the model penal code as we go through the course. Now, the model penal code is the basis for many state laws, as I've already indicated. The best example of this is New York, which revised its code of criminal laws almost exclusively based on the model penal code. One example is the New York murder statute on page 243. This is a model penal code based statute. When at times I refer to some of the Ohio statutes, you will also notice that Ohio, when it revised its criminal statutes in the 1970s, did so on the basis of the model penal code. And this is the case in many states. You will read cases throughout the semester that will refer back to the model penal code because that would be the basis for the state penal laws that are referred to in those cases. The second piece that I would like to talk about is the elemental approach to criminal law. Just as you see here, a fully developed airplane, here, this is representative of criminal statutes that are fully written out. Next to it, you have a model of that airplane broken down into its various pieces. This is what we are going to do with the elemental approach to criminal laws. So let's take some examples. Take larceny. Larceny is the taking and carrying away of the personal property of another. This is how it would appear in its full statutory form. Now, when we break it out into its elements, we see that larceny, 1 is the taking, 2 is the carrying away, 3 is the personal property, and 4 of another. Now, you may say, why would we bother doing this? There are a number of reasons. First of all, each of these elements here must have a mental element that will go with them. In addition, when this larceny case would come to trial, the prosecution would have to be certain to introduce evidence for each and every one of these elements. They would have to call a witness who could testify that the defendant took, that the defendant at the time carried away, that the defendant knew that it was the personal property of another. And this would have to be proven at trial. And the defense at that trial would try to negate any one or all of these elements. If the defense could prove that the defendant took and carried away but did not know that it was the personal property of another, then the defendant would win this trial. Let's look at another example. Here we have a perjury statute. If in any official proceeding he makes a false statement under oath when the statement is material and he does not believe it to be true, this is the crime of perjury. Now we break it down into its elements. In any official proceeding, makes a false statement under oath when the statement is material and he does not believe it is true. Here again you see that the prosecution would have to prove each and every one of these elements, and then the defendant would try and negate each of these elements. We will spend a lot of time during this semester breaking offenses down into their elements. We will also do the same with various defenses, and you will learn how to do this. In the next couple of classes, we are going to spend time on examples like the larceny example, like the perjury example, breaking down these elements. At the same time, we will give them various names that you will learn about as how to work with them, and we will discuss what the mental states that go with each of these elements. This now concludes video presentation 1.